An important thing to recognise if you're an interested person is the duty of candour. Now, what that means is, even though you may have documents which may not be as favourable to your case, you are under a duty to disclose those documents to the coroner. There's nothing more frustrating than to get in the middle of an inquest, halfway through the hearing, which may have, maybe weeks or several days, for documents to suddenly pop up, which should have been disclosed weeks or months earlier. Explain to your clients that these documents do need to be disclosed and need to be disclosed early. It's just the nature of the beast. And the final tip that I would suggest is recognising potential conflicts. Now, if you're an interested person who's representing an individual other than the family, you're more likely to have risk of conflicts, but particularly if you're representing a large state institution such as a prison, NHS trust, or the police. And what I mean by conflict, you might find that you're in the course of your analysis of the case or the evidence, that one of your witnesses under the umbrella organisation conflicts with either the organisation itself or with other witnesses. It's best to have that witness represented separately and to do so early. The reason why I say that is there's nothing worse than to be in the middle of a case and for a witness to say they need fresh representation because their lawyers can't represent them. That's in nobody's interest. A simple tip that I can offer from all my years of experience is just common courtesy. If you think about it, this is an essential, particularly in a coroner's court where somebody suffered a loss. Offering your condolences to a bereaved family is not an admission of guilt or liability. It's just something that humanises the process. And this is something we can all do, regardless of who we represent. The advocate's use of language is really important in all proceedings, but even more so in coronial proceedings. Please avoid Latin phrases or long, complicated sentences. Now, obviously, this will need to be adapted according to the witness. You're not going to be asking questions of an expert in the same way you're going to be asking questions of the mother of the deceased or a vulnerable witness. And that's something we all acknowledge and accept. What I tend to do is, sometimes you have a witness who may have trouble understanding the issues. Now, that's not because the witness is particularly slow. They may be suffering from grief. The evidence may be extremely complicated. It may be your fault as the advocate. Oftentimes, I find that lay people ask questions in a much clearer way than some of the advocates that I've come across in court. So one method that I use is I take a pause and I ask the witness if they've understood the question. And if they haven't understood, I make it clear that it's probably not their fault, it's probably my fault in the way that I've put the question. And I rephrase the question and ask the witness after the question has been rephrased, is that clear? And allow the witness an opportunity to answer it. One question that I'm often asked is, if an inquest is an inquisitorial process and non-adversarial, is it possible to ask robust questions? My answer to that is, it's possible to be firm and searching, and where necessary robust, but nevertheless polite and respectful. The style of advocacy is different, and it's important to remember it's not like ordinary litigation. It's important to remember that all witnesses deserve respect regardless of who you are acting for. I confess at times I've been guilty of perhaps pressing a witness too far on a high-profile case, but it's important to take stock, and where you feel that you may have gone too far, apologise and move on.